break time is on your seats as soon as I can get. The problem is we're gonna have to make a whole bunch of copies, and believe it or not, there is one copy machine on this entire floor. Yes, there it is. All right, counsel, we ready for our jury?
Yes, Sean.
Okay, let's get our jury in here.
All jurors are present.
Counsel, stipulate the presence of the jury.
Yes, Sean.
Please be seated. Counsel, for Mr. Franklin, do you have any further witnesses? Ms. Anderson, any further witnesses?
Stand for a second, please. Order Mr. Harris, Mr. Franklin to the stand again.
Your Honor, we object this time. This witness was terminated all questions.
On what basis, counsel, why are we
I
recalling?
just wanted to ask him to clarify one question.
You want to recall him in your
Just
case?
to clarify one question.
All out recall. All out recall.
Watch yourself up.
He hasn't rested yet.
Mr. Harris, Mr. Franklin, you testified earlier when counsel asked you that you had transferred counsel's information from his website to the website you created. Is that a fact?
Clarify that again, what did you say?
The testimony was that you transferred Mr. Harris's, when you created the new website, that you transferred Mr. Harris's information to the new website.
Just objecting to the point.
Data transfer. Okay, hold on, Chairman. Objections to form the
It
question.
misstates prior testimony.
Okay, I'll allow it. Your answer, sir?
No, I didn't transfer, Mr. Harris.
Any other questions from the council?
I have no further.
Any cross on that, Mr. Harris?
No, Your Honor.
Okay, thank you, sir. You may be excused. Counsel, any other witnesses?
No, Your Honor.
Defense rest at this time?
Please rest.
Mr. Needham, you wish to present a witness?
Mr. Del Casal.
Thank you.
Okay, thank you. Judicial District, please take the witness stand.
Watch your step on those. Standing. Raise your right hand.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state and spell your first and last name for the record, please.
My given name is Ernesto, E-R-A-S-T-O. Last name Del Casal, D-E-L-C-A-S-A-L, Jr.
Let me be seated, please.
Thank you.
Counsel, your witness. Thank you.
Good afternoon, Mr. Del Casal.
Good afternoon.
Yeah, let's, like everyone else, let's start with, a little bit about your background. Tell us, did you go to high school in Los Angeles? Begin with your education in high school.
Yes, I did. I moved here in 1961. I was still in elementary school at that time, getting ready for junior high.
Okay, I'm sorry. And can you just continue on with your what happened with high school?
Oh, my father had a stroke when I was a teenager and I had to go to work, so I pretty much took care of that.
I got you. And then your employment, as I understand, you had employment in Las Vegas at the Sahara Hotel?
Yes, 23
Objection, Your
years.
Honor, assumes that's not in evidence.
He's giving his background,
So
counsel.
counsel's already indicated his employment as he understands it, form of the
It's
question.
foundational, counsel. I'll allow it.
Okay, what did you do at the Sahara Hotel?
I started there in had to be 65, 66, I believe. And I started as a busboy. I was a teenager. And then I worked there until I was old enough to become a waiter. Then I also was a dining room captain. Went into management for about 3 months and hated it, so I went back to the floor.
Okay. And did you do any other side work besides the
Oh,
hotel?
yeah. When I was a youngster, of course, to supplement my income at the hotel, I used to do a lot of home repairs and things like that, and lawn work and that. And then I also invested in a car lot. And I used to go back and forth to Rosemead to the auction, pick up cars, and come back here and sell them. I had a car lot for a few years, back in 1980 and 81.
Is that one of the exhibits in the case, I believe, had some automobile information on there, is that?
That was my ad. And in there I used the name J. Castle, which was also registered with DMV as salesman, because you're allowed to use a alias or something a little more catchy than Ernest Del Casal, in the 80s,
We can show you what's already been marked and admitted as Exhibit 28.
Yes, that's my ad.
And this name, Honest J. Casal, how did,
That's the nickname they gave me with the other card.
is it Counsel? Say it?
Mhm.
Okay, and how did you come up with that name?
Well, a lot of people, my last name is Del Casal, but when they say Casal, they don't know the Del, they think Del's my middle name or something. So it was just a variation. The J comes from I'm a junior, and I've been called Jay since the day I was brought home from the hospital.
Okay, and I see some of these car prices, they look pretty low.
Yeah.
$100.
Objection, Your Honor.
But
It's
what I'm going
irrelevant.
is,
Hold on, counsel, hold on.
sorry,
What's,
It's irrelevant.
what year, approximate year was this?
just a year.
Yeah, that's what I'm trying to go with this.
But you can see by the phone numbers and stuff, there's no area code in the front. That was 1980, that particular ad.
And how did this ad, how did it end up in Mr. Harris's possession?
It was in my desk and left in the desk in my drawer. When I cleaned out my desk, I guess I didn't do well enough.
And they refer to this as one of your alter egos
Yeah,
from the 80s. What's your
I haven't
response?
used that name since.
Since the 80s?
Yeah,
Oh,
because when I started the organization, obviously I had to use my my proper name. So I didn't even use J at the office. I used Ernest.
did you mention that name had to register it at all, this name?
Pardon me?
Did you register this name anywhere?
Yes, with DMV on my sales license. You have to. They ask you, what you're going to go under, put on your business card, etc.
And you had started Equal Rights Workers Fathers, what, you know what approximate year you started Equal Rights Workers?
1982.
And we all know that went on for years. How about your family? Are you
Object to
married?
the form of the question, Your Honor.
As to whether he's married or
I
not?
know that we all know.
Well, I'm just going,
Sustain.
let's move to your family. Are you currently married?
Yes, I've been married 40 years.
Children?
2 children. My son is 53, my daughter's 44.
Now, Equal Rights Workers
I
Fathers,
have 5 grandchildren and 5 great-grandchildren.
Equal Rights Workers Fathers, can you tell us, describe that organization for us, please?
Well, in the earlier days, I used to
Judge,
hold,
I just object, I'm not sure exactly time and place. Foundational, when?
Okay, okay. It's just another, he started in the 80s. He's now asking what it was about. Go ahead.
Just what was it about, the organization?
it was an educational support group. What would happen on Tuesday nights is I used to hold these public meetings and invite all the attorney, 2 or 3, 4 of the attorneys. I used to put them all at a big conference table at the end of the room. And then we put all the chairs down, and we'd have like 30, 40 people come in, and we did first I did my little comedy skit, whatever, to get people relaxed. And then after that, fielded questions, and the attorneys answered questions for the people for approximately 2 hours. And then and after that, of course, people would want to come in and be part of the group, etc. So.
There came a point in, and I don't mean to rush through that organization, but there came a point in time that you sold it to Kurt Harris.
Yes.
Can you describe the circumstances surrounding that sale?
Well, I started telling everybody, and I used to say it every day in the office, that I'm retiring, I'm retiring, I'm retiring. So, and so the attorneys, a lot of the attorneys I worked with, some were thinking about buying it, 2 others in particular. But at the time, I thought it would be a conflict because both their wives were family court judges. So I didn't think it would be, they would be best suited because it could run into conflict in the future. Especially one being a family court judge and the other one being a district court judge.
So, how did you approach Kurt, or did Kurt approach you in this sale?
Kurt approached me because he knew I had other people interested.
And what sort of promises were made to you by Kurt?
He was supposed to turn it into a law office, which he did, but he was supposed to have an attorney, this is what he proposed to me, that there would be a full-time attorney and, you know, be able to do unbundled law, get these guys in and out of court fairly inexpensively. And that never happened, and I kept asking, when are we getting the lawyer, what's gonna happen here? And then all of a sudden, one day out of the blue, here comes Cam. Instead of lawyer, we got Cam.
Is there anything else that Mr. Harris wanted in regard to this deal, you know, how he wanted to
Okay,
unfold?
when Cam first came in, I was showing him the website, and it has Al Hinden's name and phone number and email all on there. And he went and he looked, and it was an old website. It had been up there for, geez, over decades probably. But anyway, it was up there, and it was real archaic and all that. So of course, he didn't want it. So, but nevertheless, when I sold the organization, I paid it 2 years in advance. It was only $50 a year. So I paid 2 years in advance. So it was paid for when I left. It did not expire until well into 2016, and I was long gone by then. And also we wanted they didn't want the email because it was an Earthlink account. And I guess I was the only person in town anymore that had an Earthlink account, so they didn't want that. So, and it was ERDF@Earthlink.
How about the bookkeeping and the accounting, how was that discussed?
Well, here's what happened. I mean, he says, I want everything to remain the same. All right. So we were still collecting memberships for 1.5 years after Mr. Harris bought it. And I mean, I remember him yesterday saying it's rather unethical to do that, but nevertheless it happened. So out of those memberships, I had to pay, because I only made $100 a day from the paralegals that are working there. So, you know, with their vig, so to speak. And so I would have to collect the memberships. Out of the memberships, I had to pay the rent, which was like almost $1,000, all the electric, all the water, everything, the garbage, the sewer, everything whenever a bill came in. And I ended up paying all of it. Mr. Harris did not pay one dime for 1.5 years of his newly purchased business. So, I mean, he got a great deal. And during that, well, go ahead,
When Mr. Harris purchased the business, did he want everyone to know about his purchase?
No. This is one of the reasons when I asked him, when he finally paid it off, it took him like 5 or 6 months to pay me off. And when he finally did, I said, okay, now we need to change, you know, the business license, we need to change this, we need to change that. And his response to me was, I don't want anybody to know I bought it yet. And I'm gonna work it off the books under the table. And which he did.
And there came a point in time where you, but that was in March 2014, the purchase, correct?
Yes.
Okay, do you remember what, when you eventually, you stayed on, pursuant to the contract, you stayed with the business?
Right.
And the purpose of that was, what made you stay
I was
on?
supposed to be training a new attorney that was coming in to, you know, all to acclimate them with the office, to say, this is how we do, this is our procedure, these are, you know, and never happened.
How long did you stay with the there until you eventually left? You know how long? When
18 months.
Okay, 18 months.
Mm-hmm.
And tell us, we've heard some testimony about the circumstances surrounding your departure
Right.
from that. Can you describe?
Okay. The first 6 months, I cleaned out my desk and everything, put it in my car, and I was on the way, and Cam chases me out, you know, almost crying, saying, oh, no, I don't know what to do, I can't run this. And then some of the members came out and said, dude, don't leave us hanging like this or whatever. So I decided, I stayed, but I made direct to Cam, like, stop making fun of minority people, stop making fun of people that are lesser than you. You know, just, it was just mean. So after that, you know, I had very little to do with him. And then the contract only required that I be there 4 hours a day. So after a while, and I saw where things were going, I just did, you know, because I knew as long as I was staying there that they'd probably keep the prices the same and the lawyers and what have you. So, but that changed too. So I used to have 9 to 10 lawyers for referrals, so I would give out 3 they were on a list, and I'd have 3 for this guy, and the next guy get the next 3, and the next person to get the next 3. So, you know, I had plenty of attorneys, but after Mr. Harris took over, it was just him. Then like the next thing was he brought in he told me it was his buddy from church, that's Oliver Melgar. And Suflita had been working with me previously, but now the tables turned. He was suddenly the boss, and I was supposed to listen to him, I guess, I don't know. But he was never there. He was there like 45 minutes a day. He'd come in, pick up the cash, and leave. Because we used to collect attorney fees. Because people didn't want, you know, if they walk in, the attorney's not available, he's in court. So it was very common practice. And just like when Mr. Harris bought the business, he didn't want any receipts either. Who spends $50,000 and doesn't get a receipt? I mean, I get a receipt for $5.
There came a point in time when my question also is, when you left, when you eventually did leave, you remember what month, and you said 18 months, correct?
Yeah, December 31st was my last day. I had received an email from Mr. Harris, and I think you have it there. And it says something to the effect of, sir, I'm gonna make some changes, and I'm gonna do this, and blah, 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 blah. So we want you to go by January 14th, which was 30 days down the road, okay? So I said, no, I want to close out all my books, everything. So I left on December 31st, which was actually much earlier than January 14th.
Did you ever receive any kind of request or concerns from Mr. Harris about passwords, domain names, any concerns about what you did?
One day when I was driving out the lake, taking all the kids out to the lake, I get a phone call, but it was on my computer. He goes, what's your password? And we all thought it was funny because I go, password. And he go, yeah, what's your password? I go, password. You know, and then so everybody was kind of laughing in the truck, but that's the only time he ever asked me for anything. The contract says if you have any problem or anything, write a letter.
Was there any concerns or anything about the contract that you're aware of that they were concerned about that you didn't do?
No, I was there for 18 months. If there was something they wanted from me, I was very accessible. I was right there every day. They have my phone number. Suflita and a couple of the other attorneys have been to my home. So everybody knows where I've had the same phone number for 30 years. I mean, easy to get a hold of. I'm all over Facebook, so if somebody was really wanting to get a hold of me, they could, you know, go to Facebook.
How about when you left the organization, how were the utilities handled?
Oh, in the last week, that's when we spent the time, because Kurt had to come in. Kurt was very seldom there also. He would just, you know, I mean, probably maybe 2-3 times a month, he'd come in for a half hour in between court and he was gone. But in the last 2 weeks, well, actually the last week, is when we all got together, and this is where I had to transfer the lease, transfer the electric, transfer everything to his name.
Now, eventually you filed a bar complaint in this case, and it's been produced. You know, tell us the circumstance, who filed the bar complaint?
Well, actually, it was one of my old clients. He came in, but he didn't want to get into it, so I said, look, just type it, and I'll go ahead and submit it. Because I didn't type at that time.
Yeah, that name appears on there, I think it's on email, they say like J. Dean.
It's Joshua Dean.
Okay, and that wasn't some alter ego of yours?
No, he lives, you can look, he's got an email out there, you can probably get a hold of him, but he lives in, Wisconsin or Minnesota or something like that, I'm not quite sure. But he's available. And that happens to be also the initials and name for one of the bailiffs here in the courthouse too.
The website that Mr. Franklin just got done talking about, did you have any role or knowledge of that website?
No, not until after, I guess it came down, whatever, Michael called me and says, do you know who so-and-so, Ryan? And I said, no, I don't know, there's so many Ryans, and he goes, oh, because the dude didn't pay me, I thought I'd find him through you or something. No, sorry. And then I get a call, because I know a lot of people in the court system, I get a call.
Objection, Your Honor. It's gonna call for a hearsay.
Bottom line is I was informed that somebody was.
An objection, Your Honor.
I'll wait till the question, please. Go ahead, Counsel.
Do you ever have an opportunity to review the website?
Not until I got to your office.
What's your overall opinion of the website?
Well,
I'm just gonna object to Sir Relevant, Your Honor. His opinion is of the website.
Are you asking him as far as the production of it, or what?
No, this is overall thoughts of the content.
And which website are we talking about now?
The website in controversy here.
Okay, so in regards to that website, sir, what's your opinion on it?
I think it's harsh, but a lot of it's very true. That's, you know. What can I say? I mean, I didn't have any part, if I had any part in it, and you'll see, in the last 30-some years, I've been very vocal about bad attorneys and bad judges in this town, especially in family court. And I've been very vocal. I make a lot of noise about it, do a lot of campaigning during judicial elections. I go to the state legislature to sit in on anything family law related. I attend all the family law seminars.
You want to finish, or have you had anything to do with it? You want to finish?
I would put my name on it. I'm not, if I was gonna say anything, I mean, when I post on Facebook or anything, even other people will send me things. Instead of putting them on it, I will put it as though, you know, they'll send me, like for my family court news page, they'll send me an article and then I just repost it. Everything that I post on there is already public knowledge. It's out there already. And I just repost. It's a family court news is a educational page, and it just goes different articles that come out. I search the net, see if I can find, like today, it's going to be whatever article pops up, latest news in family court, things like that.
And there came a point in time where you were sued. In
Yes.
this case, did you receive any phone calls or emails
No.
from Mr. Harris?
No.
Just sued.
Just a phone call could have probably prepared, you know.
Objection, Your Honor.
Sustained. Ladies and gentlemen, jury, you're informed to disregard the last statement.
And when you received the lawsuit, I assume you read it, correct?
Yes.
And what was your thoughts about content or the
Freaking horrified. I was accused of theft and vandalism and breach of contract, and I mean, it was like 7 different charges out there, and I'm like, what? This is ridiculous. Because I mean, I left there in 2015, this article or website came out in 2018, so I hadn't seen, I hadn't been back to the office since the day I left. So here we go, 3 years, and out of the blue, boom, I get this lawsuit.
some of the content or that I looked at in this complaint? One is creating fake.
Objection, Your Honor. I guess counsel's testifying essentially, it's an improper question about evidence that has not been.
I haven't put the question yet, hasn't been finished, let me listen to the question first, go ahead, counsel.
You said you read the complaint that you were served with.
Yes.
Filed against you,
That wasn't a question, Your Honor.
and you already,
He's rephrasing it, counselor.
you've already provided some phrases or allegations against you. You said that a moment ago.
Yes.
And can you list those again so I can then ask my question? What were some of the allegations that you?
Oh, vandalism.
Been asked
Let's
and
not, I
answered,
wanted to
Your
stop
Honor.
at one, then I want to stop at one of those. Your vandalism, you're saying there was no truth to that, or what?
Not me, I mean, that office is in a kind of a rough area down there in East Charleston and Mojave. And I've had it broken into 2 or 3 times. They take the air conditioner off and drop down. It's been set on fire twice. I mean, I had a car drive through. There's a lot of, problems in that neighborhood.
I believe Mr. Cam Harris, in regard to vandalism, said he would cut some strip off the window.
Oh, okay. When I was getting ready to sell, I was still there. Ed Miley had moved an office next door, because I guess he was gonna compete with Kurt. And he moved an office next door, and he never moved into it. But he did put in the cameras and all that kind of stuff. And after a while, vacated it, and he just let the lease go. There was netting, that type of, what do you call it, vinyl netting that you use for signs and stuff on the thing. And I went to the owner, who's Joe Vranish, and I said, Joe, this is because there's a door that connected the 2 offices. So if anybody broke in there, it would be easy to get into my place. So I asked Joe if I could take the stripping off so we, for security reasons, so that they could see. And he said, no problem, because the person who was using it is no longer there. So there was no value. They were going to take it off anyway.
You were accused of having fake internet accounts. What's your response to that?
Objection, Your Honor. That wasn't the answer to the question whatsoever. Counsel now testifying. From evidence that hasn't been admitted to the jury, and that wasn't one of the prior questions or answers that have been given thus
He
far.
utilized false websites or false names?
I think he said fake was the word he was using or something
Fake.
else. Fake accounts. He was talking about alter egos and the aliases that he used. Didn't say anything about fake accounts previously.
Okay, let's clarify because of the utilization of the terminology. Mr. Newman, you're talking about they used fake web pages. Let's clarify what you mean by that.
And I'm just going off the complaint where he's accused of fake internet accounts.
That's the objection, Your Honor, about that he's going off the complaint. If he should ask questions, if he wants to ask questions, and not try to read questions from some document.
Counselor, he can ask questions however he wants to articulate and whatever source he wants to get them from. What he's asking is, this is from the complaint that this man was served on. He's asking him his opinion about those statements that were made in the complaint you authored against him.
But he hasn't admitted his evidence here, Your Honor. He's just
The
talking,
complaint?
he's just asking questions about the complaint
Okay.
that no one's seen.
Doesn't have to. He's asking questions based upon it. Okay, go ahead,
Just
Counselor.
want to know what your response is to the allegation or accusation of fake internet accounts.
Don't need to. I have my own page, I have my personal page, and then I have my family court news page, so I don't. And that's the other thing, why would I even attempt to do that? Anything I want to put, I just put on my Facebook. I have one page where, a lot of lawyers that have been reprimanded or disbarred or whatever, it's sent to me by a media group here. They posted on their page. I take it from there and then I post it on my page.
How about the accusation that you had to actually be removed
That's
from
ridiculous.
legal rights?
Objection, Your
Wait
Honor.
till he finishes the
I'm
question.
sorry.
Again, he's saying, how about the accusation? Counsel, these are not probative questions. He's just saying that these are accusations. He's reading pleadings, but they're not accusations. They're alleged. And it's alleged in there, and if he wants to read the full context of it, that would be more appropriate for the jury to hear rather than his
You want him to
characterization.
phrase it as a different question rather than reading. Counselor can ask the question any way he wants, Counselor. If you object to the content of the question, that would be the proper objection. The question was basically based upon that statement, how he, that's all he's asking. Allowed to do that,
I
Counselor.
believe it's also been testified to Cam that.
Go ahead, Counselor.
You've been accused of that you had to be removed from the office.
So first I left 6 months. After that, I think I just explained to the jury that he sent me an email right around the first or second week of December. At that point, the letter, it says, January 14th, we want you to leave or whatever. I left on the 31st. I stayed the last week and made sure all the utilities, there was no confrontation. The group all took a picture together. I handed over the keys. Everybody says, thanks for 10 years of being the blah, 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 blah. And out the door I went. I've never been back. After many years in there.
Next question,
Objection,
Counselor.
Your Honor.
You were accused of having alter egos and then arguing with yourself.
I don't even understand what that is, but first of all, no alter egos, and I got plenty of people to argue with. I don't need to argue with myself.
So in regard to the breach of contract claim that's been alleged against you, what's your, do you feel you did any breach of this contract?
No, not at all. The contract says if there's anything in there that you need, write me a letter. I never received anything. They didn't want the email, they didn't want the website. They let everything expire and it was out there on, what is that, GoDaddy or something for sale or whatever.
How about the accusation that you've been accused of theft?
Yeah, where? I mean, if I was accused of theft, he's an attorney, wouldn't he make a police report or send me a letter or anything? I mean, theft is very serious.
Mr. Cam Harris said you had some alter ego or some Facebook called James Dean.
First of all, I didn't even
Let
meet.
me finish the question.
Okay.
And he says about a clown photo, or
Mhm.
can you, do you recall that testimony?
There's no way Cam could have ever seen anything about James Dean because I didn't even meet the guy till 2016. And that's when that photo was taken in front of the courthouse. And he worked as a clown at the Fright Factory or something like that.
So what is your thought or response to Mr. Cam Harris's belief that you have this alter ego or something going on with James Dean, that was your
I never
website.
even met the man until 2016. So there's no way, and I left the office in 2015, so I'd really like to know how Cam Harris was able to see, and I never used Facebook at the office.
I have no further questions, Your Honor.
All right.
Mr. Anderson, any questions?
Yes,
before I get
Judge.
public?
There was testimony about how angry you were in the office. Could you explain that?
Well, you can't run a men's group and be like Rebecca Sunnybrook Farm. I mean, keeping 30, 40 guys a day, that are emotionally upset, they're all, it takes a bit of work. And you have to be a little gruff and keep people in line, and I was their elder, so to speak, so, yes, I do, I bark a lot, but that's it. Make a lot of noise.
What are you barking about?
Sometimes people they come in the office and they get ridiculous with their expectations and things, so we have to settle them down. Like you said, we used to all sit in the waiting area, and I kept my desk right in the front, so when people came in, they could sit down and talk. We'd all have these big conversations and sit there all day long talking. I always kept the refrigerator stocked with beer. I mean, so, there was always food. Like, we used to tell people in the morning, if you come, bring donuts, in the afternoon, bring beer. So it was a clubhouse. It had the atmosphere of a cheap beer bar.
There was testimony by Cam that you stole money from the office. Could you explain that?
Objection, Your Honor, that misstates testimony.
Standing counsel, that's not what he said.
Yes, Cam said that you took money from the office.
Counsel's arguing now, Your Honor, and that's
No, the counsel, the statement was that employees would pay him.
And you took the money.
Okay, that's different than the accusation you just made, that somehow he stole the money. Asking the question based upon Mr. Cam Harris's statement was that this individual would take money from the other employees in regards to payment. That's different than the statement you made.
Could you explain that, how did you take money from other employees?
Yes, 10%, and that money went, of course, to the rent. I mean, like I said, my expenses were $2,000 a month. So, that little bit of money that they gave me didn't cover all the expenses, because I still had a salary. My wife had a salary. There were other expenses to go on with it. I paid all of that for 18 months. There was no stealing. I paid for it.
During the 18 months when you were paying, was that after Mr. Harris bought the?
Yes.
There was a part of your agreement with him when you purchased that he would pay you an amount upfront for the business, and then you would get other monies from the office. How did that work?
Well, there wasn't any other monies, so what happened was everything had to be taken out of the membership. So Mr. Harris was still charging membership for 18 months. I paid the office rent to the tune of $18,000. I paid for the electric. I did everything there.
Were you reimbursed?
No,
Did you and Mr. Franklin get together and do that website?
the last time I saw Mr. Franklin, and I usually don't stop there. I stopped at that market on Nellis in Vegas Valley. I was in there. Mr. Franklin was there with his 2 daughters. I recognized him. He recognized me. We started talking. I told him I sold the group, etc. And he's like, "Oh, wow, it's too bad," or whatever. And I said, "No, I'm tired. I'm moving." So that was our conversation. I talked to his daughters for a couple minutes, and we were done. That was it. That's the last time I saw him.
You started the group and you stayed there, but for 18 months, you said, after Mr. Harris bought the
Correct.
business. What, if any, changes were made during the 18 months that you were there with Mr. Harris that was different than when you ran it?
Well, what's different is that we still kept the same prices as long as I was there. Those prices didn't change until after I left. The prices stayed the same. The only difference was we were now limited to which attorneys I could refer people to. So I went from 10 to 3.
How much, let me just rephrase it, let's draw the question. Was there anything in your agreement with Mr. Harris that you would not compete with him?
No, I'm just gonna object, Your Honor.
No.
It's irrelevant.
Sustained. Next question, counsel.
When you when you ran the office before Mr. Harris bought it, were there any attorneys working there?
Oh, yeah.
I'm just gonna check.
Not
Ask and
in,
answer.
not in the office.
We can go for clarification. Go ahead, counsel.
At the time when you ran the office,
Mm-hmm.
were there any attorneys working there?
No, they would all come in, daily or whatever, but there was nobody actually sitting there, so. We didn't utilize attorneys until the client came in or the member came in and wanted the cards. Then they had an option. They could do, number one was go see the lawyer right now, because they were free consultations. Number two was get your papers drafted and then take them to the lawyer. And a lot of times the lawyers would come back and they'd redline stuff for me and ask, the paralegals to make changes, because I don't draft. I've never drafted. I've never drafted a single document in my life. And then the third option, of course, was, people that just said, look, there's no sense seeing a lawyer. I mean, I said, even if you go get some free advice before you appear. So then there was that option, because some people just cannot afford an attorney.
So were there, the people who were working for you were non-attorneys, were they drafting documents?
Yes, they were.
And how did they make sure that those documents met the law?
And this is why I gave the option. This is why I said, here's your, attorney referrals. Take the documents over there, which was my preference. And because then it did two things. Number one, introduced them to the lawyer. Number two, if there was anything that needed to be redlined or changes, I could make them.
Did that change after Mr. Harris purchased the business?
Oh, yeah. What happened now is you can't see anybody till you get your paperwork done. Yeah, they even tell you on their website, will tell you when you need an attorney.
So what, based on your 18-month there, were the paralegals still drafting documents?
Yes.
Were they being, based on your experience there for the 18 months, were those documents being reviewed by attorneys?
No, because now the system changed. Once Mr. Harris got it, then I used to, like I said, I had plenty of attorneys out there, and I used to keep them on a rotating basis, but.
Mr. Harris said that every document that the paralegal drafted, he or another attorney reviewed them.
I'm gonna object to the,
Go ahead.
thank you, Your Honor, sorry. That misstates my testimony.
Sustained.
Mr. Harris said that any document drafted by the paralegals were reviewed either by himself, they were faxed them to him, or was that true?
Again, I'm objecting to this question. It misstates my testimony and lacks foundation.
Okay, the statement was that all of these documents we're talking about, counsel, documents to be filed were in fact reviewed according to Mr. Harris by himself before they got filed. Okay, that's what you're talking about?
Yes.
Okay, so phrased that way, Mr. Harris, it does reflect what you said. Documents that were to be filed had to be reviewed before
But she's
filing.
talking about it pre,
That's what I'm saying,
As opposed to
we're gonna
post.
clarify it.
Okay.
Post purchase by Mr. Harris.
Yes.
Okay, so post purchase by Mr. Harris, documents that were to be filed, you know what that means,
Yes.
to be filed. In your opinion, were they reviewed by a licensed attorney? No. Okay, next question, Counsel.
You said you reviewed the information on the website.
Eventually, yes.
What, if anything, there you considered, like based on your experience before and after, false?
I'm gonna object, Your Honor. I guess she's calling for, this witness testified he had nothing to do with it whatsoever, so his opinion would be irrelevant to it at this point.
I'll allow it.
Oh, I read it, and like I said earlier, there's a lot of truth to it. So I think whoever wrote it, their delivery maybe wasn't so well, but the content, the information that's there is fairly accurate.
I have no further questions, thank you.
Okay, Cross.
What about it would you say was accurate?
Oh, that you're dishonest and not trustworthy? I read that in there.
And is that what you believe?
Well, you asked me what I said in there, as far as.
What you said on the website?
No, not what I said on the website. You just asked me the question, all right? There was, I think you're dishonest, I think you're unethical.
Okay. We had a contract, correct?
Yes?
What part of that contract did I not live up to?
Well, it wasn't the contract.
No, I'm just asking the
Okay.
question. Answer the
It's
question.
fine. Nothing. You did fine,
So I complied 100% with our contract.
as well as I.
I'm just asking a
Mhm.
question. Can you
Yes.
answer that? That's
Yes,
yes.
it is.
So every single term of that contract was met.
Mhm.
Is there one
Well, all
single
it was
term,
50 grand. It's-
and that was in cash? that you
Yeah, over a
demanded,
period of
correct?
time, yeah,
And you
$5,000 a
Hold
month.
on, quick question, so it was $50,000 cash, he paid all that, correct?
Right,
And you didn't give me a receipt for the payment,
you
did you?
didn't want it.
Because you didn't want to declare that,
No,
right?
that's not true. You were the one.
Why would I not want to declare a capital expenditure that I could take off my taxes for $50,000? What business owner wouldn't want to have a deduction of 50 grand?
What attorney would not get a receipt for 50 grand?
Someone that trusted the person they were
So,
dealing with.
so.
Okay, hold on,
that-
counsel, let's, again, we're not gonna have an argument back and forth, gentlemen. The question was, what businessman would not want a receipt? Are you asking him his opinion on that?
Yes,
Okay, Discal, do you have? an
Somebody
opinion
that
on
didn't want a receipt, maybe didn't want anybody to know that they owned it, they bought it, maybe they were trying to hide something.
but you don't know.
Oh, yeah, I do.
And how do you know that?
Because of our conversation.
How much time do you spend each week? And let's just say over the course of the last, I don't know, 3 years, 4 years, 5 years, how much time have you spent weekly on the internet posting about others?
Oh, not that much. Usually I post one item on the family court news just to keep the page going.
Just want to know how much time.
Takes me, what, 10 minutes maybe?
Okay, and you have several web pages, don't you? You said you're all over Facebook.
Right. I'm also the administrator for Golden Valley, Arizona Living.
Do you ever make any opinions about me in Arizona, Golden Valley living?
Not that I
Never
know.
posted about
There's
me?
no, it's irrelevant to those people there. They don't care. They're all retired and stuff. The only thing they need is an attorney for is probate.
Testimony is never?
In Golden Valley?
Yes,
Not me.
okay. And you just say that you had children and grandchildren, correct?
Yes.
And you, for this time that you spend posting online, is your testimony you just don't have anything better to do?
Well, I'm retired. I spend a lot of time. The only communication with the world I have when I'm in Arizona is my little phone.
You stated that I got a good deal on the business. Is that a justifiable reason to defame an individual because they got a good
I've
deal?
never defamed you,
I'm just asking, do you think that's the basis of a reason?
and I didn't do it. I keep telling you that. I've told you for the last 3.5 years.
Are you under the influence today?
No, I'm not. Are you?
Okay. And when was the last time you were under the influence?
Well, I know where you're
Hold on,
going.
hold on a second, counselor. First of all, let's make sure we understand something. You ask him he's under the influence of what? Marijuana, street drugs, prescription drugs?
Of any
alcohol?
intoxicating substances, Your Honor.
Okay.
The
At
only-
this current
the
time,
only-
at this current time you're asking him?
Yes.
He said no. You're asking him when's the last time this gentleman?
Yes.
What's the relevance?
To make sure that he is competent to testify here today.
Okay, he already said he didn't consume anything today.
Okay.
He's not under the influence today. Are you asking him whether or not that he consumed any type of alcohol or intoxicating beverage in the last 24 hours?
Yes, Sean, that would be the next question.
Del Casal, did you?
What? No.
Okay, the next question, Counselor.
Did you
I think
smoke
there's-
marijuana while you were at the office?
I smoke CBD.
Okay.
And now, because of my medical condition, I just do edibles.
And did
But
you know that?
CBD does not
and
have
did
any
you know- and did you-
intoxicating
Answer the
effects.
question, please.
He's a fashion. So he's saying that he consumed CBD.
And did you know that that was problematic to me?
You were never there.
So did you know that that was
Did you?
problematic to me?
No,
You didn't know that?
no. I have a medical
Did,
marijuana card.
you
If you had an
indicated-
issue, you should have said something.
You indicated that you don't like Oliver Melgar?
I never said I don't like Oliver.
Okay.
He's your,
So is he okay?
Yes. I don't know him that well.
You don't
Even
know?
you brought him in and all I did was refer people to him. He'd stop by every now and then and make a check out to my name for advertising.
Did, you indicated that I made multiple statements to you. Was anybody witness to those statements?
My wife, myself, your,
Are you gonna bring her here to testify today
No,
about those
her
statements
health
that
is
you
not gonna
alleged
be-
that I
she
made
can't
to
do it with
you?
her
Please
health.
let me finish my question.
Guys, we're not gonna do this again, last warning.
Please let me finish.
Ask a question, make a complete question, stop, allow him to answer, you answer, allow him to ask the next question.
Are you gonna be able to bring anyone here to testify to any of these conversations that you and I had at trial?
no, I was sitting at my desk and you were standing next to me.
And you
And
don't,
that's what you said.
and you don't have any independent witnesses who were willing to come and testify or of any of these representations
it was
that
the
you
first time?
alleged, please let me finish, that you alleged that I made?
You said it to me directly. It was a private conversation, and you know it.
So is the question no? Or your answer no to the question?
Give me the question
You
again.
don't have any individual, please answer, please listen, I guess what I'm saying.
No,
You don't have any individuals who are gonna be able to come here
no,
and testify that any of these communications or conversations ever occurred.
no. But I know.
And have you were any of these communications or statements that you referred to, were they contained in the contract?
No.
And the contract was our deal, correct?
Right.
And there was no promises or
There
other
were plenty of
circumstances
promises.
that extended beyond the contract, were there?
There were oral promises from you.
Okay.
It never happened.
And did you put those on paper?
No, I didn't write the contract. You did.
Who asked me to write the contract?
Not me. It was your idea.
Did the contract say anything about making changes to the business?
I don't remember. I doubt it.
Did you contact me about any breach of the contract?
No. I was gone. 2015. I was out the door.
Were you angry when you left?
No, not at all. I was glad to go.
Does a business have a right to change?
They can do
The way
whatever
they
they
do
want.
things if they
Doesn't
want
bother
to.
me. I don't care what you do.
Well, to some degree you do care what I do, right? Because you post about me quite a bit.
Well, because your office does some terrible things.
Do you remember?
And all I post,
Do
excuse
you
me,
Hold
remember?
on, counsel. Let him finish
all
this.
I post are things about you that are already on the internet.
Let's talk about your reposts, okay? Now, you remember having your deposition taken as well,
Yes.
correct? And do you remember at the deposition that I asked you questions and you gave me
Right.
answers? Is
Mm-hmm.
that a yes?
Yes,
And do you remember that you were under oath at that time?
yes,
And do you remember that I asked you within the last year if you had posted any Google reviews about any other attorneys other than me at that time?
yes,
And do you recall what your answer was?
yes,
What was your answer?
yes.
And who were they?
Oh, go to the
And
page.
the
and
question
you'll
was
see
a Google
Sir,
review.
he asked your question.
Okay.
Who else did you post about?
A Google review.
a Google review during litigation or before?
The question at the deposition and my question here today was.
Yes, I've put Google reviews out there, but I didn't write the reviews, I just share them.
Why?
Well, don't you think the public has a right to know what's going on at your office? Unlicensed practice of law, no attorneys there. When I was there, I don't know what you've done, and I don't care since I left, but while I was there, that was definitely UPL. There's no doubt in my mind.
So you're saying while you were there, that there was the
It was your
unauthorized
business.
practice of law that was ongoing?
It was your business
And
at
you can
that point.
understand why you needed to leave?
I wanted to leave.
And you understand why I wanted you to go?
I wanted to go. You and your son are the one that wanted me to stay. I have never had an intention of staying past 6 months.
Do you have something in paper or in writing that asked you to stay?
No,
Thank
it
you.
was your verbal
Thank you.
and Cam.
Thank you. And you also indicated at your deposition that you delete your texts?
Yeah.
Every day.
Why wouldn't I? What do I want to keep all the junk on my phone for?
And that way you can't identify anyone that would send you a text or a post for reposting because you delete every text immediately.
No, that's not how it works. They contact me through Facebook,
Mhm.
and they send me and then ask me to share it. I share it.
Can you tell me one person, one name of one individual that contacted you through Facebook in the last 2 years with a Google post about me?
Oh, yeah.
Just one.
There was this young man, I think.
What's his
girl-
name?
Wait a minute, I'm going to tell you in a minute. I know his significant other's name, Liana, and his name is, I can't remember his name, but Liana sent me a review that she did or something, so.
So no name of an individual was my client?
It's, well, you can look on Facebook, it's Liana's husband, so I'm trying to remember, it's been so long since I, had any dealings with them. Their case is long, long over.
So, did you recently repost that? During the litigation, actually got in trouble for it?
Yeah, but it's just something that's out there already on the net. What are you ashamed of?
You violated a court order, correct?
That's not the way the court order was written. The court order said not to use the website, which was the one in question during that. And I guess everyone else can remember that.
And including the judge,
Mm-hmm.
didn't remember it the way you saw it.
Judge Bear was the one that set it down. When it got transferred, like 3 judges later, I don't think anybody realized that it was just about not utilizing the website, which I had no control over anyway. And so of course I agreed to that.
I'm just going back. Can you just name one person?
Why do I have to give up people to you? No,
Thank
I'm
you,
not going to.
thank you. You said
Were you
that
gonna sue
you
them?
haven't been to the office, but you have driven by quite a bit, correct?
My auto mechanic is there, and I also do work at the swamp. I take the swamp coolers down the street, just like 4 buildings from you, and I haul those to Arizona.
And you do that weekly?
Maybe every 2 weeks, because I'm only in town 3 days a week now.
You haven't been at the location in quite some time, correct?
Correct.
And you have no idea how the office operates, do you?
Nope, I only know when I was there.
You wouldn't be in a position to comment upon any of it, would you?
Not me, other people though that go there comment.
I'm asking you.
No,
And you are unable to, no, strike that. No further questions, thank you.
Redirect, Counselor.
You were asked a question, Mr. Del Casal, about the contract
right.
and whether Mr. Harris asked you specifically whether he performed the contract or you performed the contract. And as I understand, you answered an agreement as to both of you, correct?
Right.
Now, what about on the contract, there is a section, and we've all looked at it, it says notice
Mm-hmm.
to write each other if there's an
Right.
issue.
Which I did.
I'm just gonna object, Your Honor, it's beyond the scope of cross.
No, I'll allow you to talk about the content.
So the question is, Ernie, there's a notice section on there.
Yes.
Do you feel that Mr. Harris complied with the notice provision?
Your Honor, it's been asked and answered that I complied with all the terms of the contract.
And now he's asking a specific one, and apparently this gentleman is willing to say a different answer, so let's listen to his answer.
Do you feel Mr. Harris complied with the notice provision?
Not with the notice provision.
Okay, why is that?
Because it says in there that if you have any issues, whether just write a letter. Well, I contacted Mr. Harris a couple times by email, and he never even responded to me. And then he has an obligation, I believe, according to the contract, to contact me if there's any problems or issues or anything. And so he never, 2014, 15, 16, 17, 18, 5 years, he didn't want the website, 5 years, he didn't want an email, 5 years, he didn't want anything. And then suddenly now I'm being sued for all this, which I had nothing to do with.
And the bar complaint that you filed, did you receive a phone call from Mr. Harris in regard to the bar complaint?
Your Honor, it's beyond the scope of cross.
Sustained.
You mentioned, can you repeat your last answer about emails?
Object to the form of the question, Your Honor.
I'll allow it, just a
Can
repeat.
you
of the
just
statement.
repeat the last answer? I didn't know the last few words.
Yes, I sent him a couple emails regarding problems, like all my mail.
This is beyond the last
I think-
word,
I think
the last
you're-
answer.
Counsel, sit down. The statement was that he did in fact make some emails and that he didn't have any response from him during that 5-year period. Move on, counsel.
That's what I want to hear. Thank you. What would be your, Mr. Del Casal, in terms of his lawsuit, and you're here today, what would you want, I haven't finished the question, counsel.
It's already objectionable.
Okay. Mr. Del Casal, what do you, in terms of this lawsuit, your overall response to it, I think you may have asked that originally, can you tell me what your thoughts are, what you want to see happen in this case?
Objection, Your Honor, goes well beyond the scope of cross.
Sustain.
Okay. No further questions.
Can you read the record first?
No, Your Honor.
Any questions from the jury? Okay, go ahead. Counsel's approach. So I'm going to ask you questions from the bench. Number one is, how do you know that the people who are commenting/reviewing have been to the ERD offices?
Due to their comments that they're making.
Okay. And do you confirm with these people that they are clients or have been of the offices?
Sir, I don't talk to them, I just Google, somebody puts a Google review out there and it says they went to equal rights, et cetera, all I do is repost, I don't.
You don't do anything to confirm that they were actually clients, you just repost what they posted?
Yes.
Okay, counsel, any questions in regards to this?
No, Your Honor.
Okay, thank you, sir, you may be seated. Thank you. Mr. Needham, any other further witnesses?
No.
Okay, counsel's approach quickly. Ladies and gentlemen, because of what we're gonna do now is, Mr. Needham, at this time, does the counsel for the defendant, Del Casal, have any other further witnesses?
No.
Does the defense rest? At this time, defense, do you rest?
Yes.
Counsel for the plaintiff, any rebuttal witnesses?
No, Your Honor.
Ladies and gentlemen, due to the fact that we do have no longer any witnesses, we do have some preliminary stuff that we have to handle with it, so you guys get another break. What'll happen after the break time is on your seats as soon as I can get. The problem is we're gonna have to make a whole bunch of copies, and believe it or not, there is one copy machine on this entire floor. Yes, there it is. At least it's not back in the good old days when I was teaching school and we used to have to do the drum. And you used to go home with purple fingers. So there'll be a little bit of extensive break because we have to finish the motion practice and I have to have all these jury instructions done. So we're gonna give you a little bit lengthier break in regards to that. Once you come back, I am going to be reading the jury instructions to you, which is the law. After which time you'll be hearing closing arguments. Depending on how much time we have left, we may send you out to deliberations this afternoon or first thing in the morning. During this recess, you're admonished not to talk or converse among yourselves or with anyone else on any subject connected to this trial, or read, watch, or listen to any report of or commentary on the trial or any person connected to this trial by any media information, including without limitation, newspaper, television, radio, or the internet, or a form expressing an opinion on any subject connected to this trial, the case is fine submitted to you. Not to do any experiments or investigation regarding any matters raised in this trial. You should be able to do this in one breath. Nor are you to post on any social media forums about the trial or attempt to investigate anything you heard in this trial using any form of social media or the internet. We will see you guys back here based on that clock at 2:45. All right, counsel, the other thing that we have an issue with before we get to the motions is, the one thing I have yet to see is verdict forms.
I did submit verdict forms prior to the,
Trial.
one of the multiple trial settings, Judge, and I do not have any with me today.
Do you know which one they are? We try to find them. They were submitted, were they actually filed?
No, I don't believe I filed them, Judge. And this was quite some time ago. You know, we had multiple trial settings. And
Right, I understand. I know I was the last judge that received this case. I know it's been moved.
I do not have a Word copy with me even.
Counsel for defense, do you have a verdict form?
thought I had, Judge, I think in my other suitcase, so I looked at them. I checked out, but I believe the office provided me with some
Well, I need verdict forms. You know, we have to submit this jury. I'm going to be sending this jury out, so I need verdict forms before they go to deliberation. So, Mr. Harris, if you can contact your office and have them emailed to me from the source, or if you can get on your computer, you think because they weren't submitted to me, so I don't have a copy of them.
They were not.
They were never filed, so I don't have a way to do it. I need 2 verdict forms for the defendants. You guys better get to work. Okay, now counsels, do I have any motions pending?
Just a motion you have there, Judge.
Okay, let's go ahead and hear it. I have before me a motion for judgment as a matter of law pursuant to NRCP 58. Go ahead, counsel. Make your
So I don't
argument.
want to read the whole thing, but you have
Give me your argument.
you have it there mostly. There is on page 1, there is an issue with Mr. Franklin that he acted with malice. There is no evidence here that Mr. Franklin acted with malice.
Okay, is malice the only standard for punitive damages? The malice oppressive or conscious disregard? Is that not the standard?
That's correct, Judge. And
Okay.
there was no evidence of that in this situation. And I'm not going to say that, I'm not going to read the whole thing to the judge
Okay.
because you have it. As to various statements made in the document that Mr. Franklin published, he said that this was from another person who asked him to do so. He did not believe any of it was false. He tried to verify it. He did not get a chance to verify it because he couldn't contact the person who gave it to him, and he took it down immediately or within 24 hours. There was, in fact, no publication of that or it was limited publication, and therefore there's an argument as to whether or not he did defame Mr. Harris or his business. There was no damages. Mr. Franklin did not enter into a contract with Mr. Harris, so there's no claim for breach of contract for him. There was the issue of whether or not Mr. Harris and Mr. Franklin engaged in theft. There is no evidence that Mr. Franklin engaged in any theft. He said that the website was available when he went there and he bought it. So there was no proof of damages, or there is no proof or no evidence was presented that Mr. Franklin stole anything from Mr. Harris. There was no evidence of him conspiring with Mr. Del Casal for anything. He did talk about the business and in the website, and even if there was disparagement, there was no evidence of any special damages, which is one of the requirements for damages for disparagement. So on those counts, and I submit the other claims in the document, Judge.
Thank you, counsel. Mr. Harris, opposition?
Oh, thank you, Your Honor. And I have a motion as well, Your Honor. I think that testimony and evidence is very clear here with regard to what's been brought up there, that he testified very clearly that he was complete, utter conscious disregard for the rights and others. When he published recklessly, willfully, he went out there without verifying one thing, and he made this publication to the world. He did misrepresent how long it was on the air, but even with that, it doesn't matter how long it's on the air. It doesn't matter if it's 10 seconds. It's publication, and that fulfills that requirement of publication to a third party, because it was seen by a third party, and so it's been nonsensical that they just said it's up and down. There's been adequate evidence here with regard to the claims, and one of the things they've always missed, ever since the initiation of the claim, they've always been off. The theft was the theft of the traffic. It was the theft of lawful traffic to my website that he thieved. And to say somehow that I wasn't involved at all in any theft, he admitted it this morning. Yeah, I did it. I voluntarily did it. And as a matter of fact, the client didn't even ask me to do it. He says he did it all on his own fruition and all on his own initiative. And that's a theft of traffic, that's a theft of property. I know that we're getting into the intellectual property, but that's going to become the third property, I think, in the future. It is intellectual property that he took unlawfully and with conscious disregard for what harm he would do to my business, what harm he would do to others. There's been ample testimony and evidence on that, as well as his own testimony himself. He admitted it. With regard to the other evidence that's been submitted, we painstakingly have gone through all this evidence that clearly he's linked, clearly he's a party to this, clearly these two individuals have an association, and their Rule 50 motion should be denied.
Counsel, you're saying that you have a motion in addition?
I do, Your Honor. I would like to make the same thing. At the close of evidence, when all parties have had the opportunity to be heard, that is when we have this ability to make this Rule 50 motion, Your Honor. I believe that when you look at the evidence that has been presented and the burden of proof, which is a preponderance of the evidence, it is quite clear that we have met every burden on every cause of action. As was stated on the theft cause of action, Mr. Franklin admitted that he stole the web traffic, that he redirected that, and he did that all on his own initiative. That was clearly made and that was clearly established. I believe the conspiracy claim, Your Honor, between these parties, really, there's just so much evidence that it's hard to believe that these two individuals did not act in concert. I think it's beyond a reasonable doubt that these two individuals acted in concert to make this publication. Again, going back to the preponderance, it's just a feather over 50%. And there was so much evidence that was presented that I could go through, and I did, over and over again, the connection to these two individuals, the publications and the republications. With regard to defamation, we believe the conspiracy does tie in Mr. Del Casal, but in addition to that, Mr. Franklin initiated his own defamation and ran his own campaign about false information, stating things like extortion, untrustworthy, corruption, fraud, all these things, none of which he had any proof of, nor did he even approach, he was got no evidence. He brought nothing at all to the table. And so on that issue, he should be held responsible, and the Rule 50 motion should be granted with regard to defamation. It was about my business. It was about me as an attorney in my practice. For the defamation per se, it certainly should be granted. There's no question these two individuals conspired together, that they worked together. The information is overwhelming, although not perfectly proven. It's very difficult for anyone to think that it's not clear and convincing proof here, that we haven't achieved that standard, which is a burden we don't even have to get to. The preponderance is easily made that these two guys worked together to do this. You've seen all the multiple postings, and again, I don't believe reasonable minds can differ on the association and the similarities between the website as well as the bar complaint. In addition to every witness that came in and testified that it was their belief that only that information that was on that website was in the possession of defendant Del Casal. Your Honor, we don't think there's a reasonable doubt here. I think it's clear and convincing, and if we're going down to a preponderance of the evidence, it's quite simply a shut case with regard to the evidence that's been presented here, Your Honor, and we believe that that motion should be granted and that judgment should be entered in our favor. They've had an opportunity to fully be heard at this point, and they've brought nothing to the table that would suggest otherwise, other than all the evidence that's been submitted against them.
Thanks, Counsel.
Thank you, Your Honor.
I have something, one thing, Your Honor. And this goes again to the effect of the lack of special damages in this case. Obviously, it depends on how the extent of that. I believe the breach of contract. The evidence shows Mr. Harris even just examined Mr. Del Casal. They both had an agreement that the contract was fully performed, except for if anyone breached, it would have been Mr. Harris for not performing the notice provision. But if he had any problem at all, just note that that was breached by Mr. Del Casal performed the contract. I think it was like for years later we get this lawsuit, four years later. So I think the contract's been fully performed. I don't think they should have brought breach contract. It wasn't breached by Mr. Del Casal. And I think he's going to the domain name is what I'm thinking he's going, which was abandoned by his own admission. He didn't purchase it. So how can Mr. Del Casal breach a contract over a domain name that he abandoned?
What did the contract say about the website? What does the contract say about it?
It does say that it does list a website on that.
And that it was to be turned over correctly?
Right, and
Was that turned over, Counselor?
Yeah, he tried
Did he turn it over? Did he turn ownership of the website over?
I believe he turned that information over. In fact, he said
Information or ownership, two different things. Did he in
he
fact,
didn't own he had Al Hinden who would contact or try to contact.
look at the contract and the interpretation of that contract, could reasonable minds infer on that contract that the website was to be part of the ownership and the property that was to be turned over?
I don't think there was an issue. In fact, they never sent any concerns over that website. In fact, I think they admitted they wanted to get away from this negative energy.
Well, I understand, counsel, that there's evidence on both sides. What I'm saying is there evidence that says that the jury could say that the website was part of the property that was part of this business that was to be sold.
I don't think it was ever an issue. I think that there's a form that Mr. Harris prepared, and I'm saying.
That he had to comply with.
And he fully performed as our position. I don't think there's breach of contract at all. And in regard to the theft and the web traffic, Mr. Del Casal didn't have anything to do with the Google listing and redirection of web traffic. I think those theft or conversion charges should be, or the evidence suggests that those should be, judgments be awarded in favor of Mr. Del Casal on that. In regard to the conspiracy and defamation, the evidence from Mr. Michael Franklin was that a person named Ryan hired him.
Objection, Your Honor.
These aren't our time for objections.
I'm sorry.
Right. A
Forgot where I was.
person named Ryan hired him. Michael Franklin said Mr. Del Casal didn't hire him. Del Casal said he didn't hire him. So it's really unfair for Mr. Harris to continue pursuing this on all this evidence. He has no evidence of that Mr. Del Casal participated or even knew about this website being created. No evidence at all that they were even in any contact with each other before. So it's really unfair to keep pursuing some conspiracy claim based on that evidence and based on the testimony. So I think a Rule 50 motion should be granted in favor of Mr. Del Casal on that. And again, the lack of special damages extends to all the cause of action that have damages, special damages as an element.
What about the per se damages, Counselor?
Except I'm saying all the claims that have a special damage element, like disparity.
Defamation per se has a special, just call it per se, but it's special.
Yeah, anything that goes to that should be dismissed. And the judge will go in favor of the defendants to the extent of the special damage requirement. That's it for me, Your Honor.
Counsel, respond to that. In regards to defamation, in regards to those things, the disparagement of the business, you've got a statement by you between $25,000 and $40,000. We've got statements of your son that says we lost traffic for about a week, $15,000 is what he estimated. He estimated as an employee of your company, he spent about $7,500 of time in trying to basically erase that. That I can understand as damages, either one for the contract or two for the disparagement of the business. But the defamation portion, not the defamation per se, because those are automatically presumed damages. That's why it's per se. The question is on the defamatory statements towards you and your law firm, what proof of damages have you established in regards to that portion?
You're there, Judge.
Okay.
Yeah.
The defamation portions of it is now by granted under 50A. You haven't proved the damages on the pure defamation. Okay? That portion's out. The breach of contract, indictment as far as the business impairment or the interference with the business is still staying, and so are the conspiracy and the defamation per se. But as far as the defamation, due to the fact that plaintiff has not presented imputable damages for that portion is out. So make sure your jury verdict has that out, Mr. Harris.
Understood, Your Honor. One last point I wanted to make. MCNW Marketing is a defendant in this case, made no appearance, has not been here, there's no attorney. We'd ask the judgment be entered against them.
Once and if you get a judgment, Counselor, you can then move for that. We don't have a judgment yet, so how can you render a judgment against them?
I'm making
Trying
a
to
Rule
default
50.
them, you're saying that they have not, you're saying a 50A, that they have not presented a defense, and therefore they should be on the verdict form, and if anything they have, they can't do, because they can't argue against it, because they haven't presented any kind of witness for it, nor is there a corporate representative that's gonna argue about it. Counsel, is there?
Your Honor, the defense did not have a burden to provide anything. This is a plaintiff's case, it's a plaintiff's burden.
Correct?
Your Honor, there was one issue, and the fact that the business name itself, Eco Rights for Diverse Fathers.
We're talking about a different business, we're talking about Mr. Franklin's MC and whatever
I
it is.
just have a different issue. And the concern that we put in the papers, Equal Rights for Diverse Fathers, in fact, that's the name of the website too, the domain name, Eco, is not a plaintiff, of course, and not the caption, and nor are they listed under a plaintiff. So the question of the court is, we feel that whether that's necessary or not, whether they should be in a caption. Personally, it seems very common or customary for a DBA to be in a caption, at least, at minimum, if not a plaintiff.
So you're now moving to change or alter the caption to say what
No, I'm just saying that I feel that there's to the extent that defamation claims or breach of contract claims go to that name, I think that there is a issue there in terms of whether the claims could stand or the effect of that.
And he's not made any claims on behalf of that website, he's made claims on behalf of his law firm and on behalf of himself. That's the only claims he's made.
Right, I don't, if there's any, but it seems to me like Equal Rights for His Fathers is mentioned on the website and the disparagement of that, but yet they're not in the caption, so I just want.
It's too late for an argument in regards to that, counsel. You got 15 minutes to give me verdict forms, guys. I'm gonna start reading my jury instructions when they come back.
We got 50 minutes right now? Thank you.
Get going. All right, counsels, I have before you the jury instructions. What we're gonna do is we're gonna read them, bring to the jury. Sheriff, it's my understanding you've been able to come up with a jury verdict form, is that correct?
Well, one that I have, Judge, is a little.
Okay, well, this is what I'm thinking, counsels. It sounds like we don't have verdict forms, which I am slightly. But it looks like by the time I read these jury instructions and by the time we do close, I don't think we're gonna have any time for deliberations. So what that's going to do is that's going to give you guys the opportunity this evening to make our verdict forms. Make sure you pass them by each other, because at 8:30 in the morning, you're gonna present them to me, either the ones that you've agreed upon or arguments in regards to ones you haven't agreed upon, so we can get them to our jury by 9 o'clock so they can deliberate. I can do closings as long as we have the verdict form before they start deliberations. Once they start deliberations, I can't interrupt them and then bring in a verdict form. So what I'm doing is it's gonna give you guys the opportunity this evening to craft the verdict forms so that we can supply them to them so that they can go in deliberations, okay? You guys are gonna have to get together, you better be able to stipulate to the verdict forms.
You know, I had one question, thank you.
We have for defendants.
We had, when we were discussing jury instructions in your office, there was a few instructions you wanted to wait until Mr. Del Casal testified. I think it was like 3.
Yep, and I go through them and not include them, counsel,
Okay.
based on that testimony. Okay, let's get my verdict, my jury in here, because they've been waiting long enough.
All rise for the presence of the jury. All jurors are present.
Counsel, stipulate the presence of the jury.
Yes, Your Honor.
Thank you. Ladies and gentlemen, before you, what you have is what's known as the jury instructions. I'm going to be reading them to you, and I'll ask that you follow along. Members of the jury, it is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law as to the facts that you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in these instructions. Number 2, if in these instructions any rule, direction, or idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others. But you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. 3, one of the parties in this case is a corporation. A corporation is entitled to the same fair and unprejudiced treatment as an individual would be under like circumstances, and you should decide the case with the same impartiality you would use in deciding a case between individuals. 4, the masculine form as used in these instructions, if applicable as shown by the text of the instruction and the evidence, also applies to a female person or a corporation. Although you are not to consider only the evidence in the case, although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witness testified. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. 6, if during this trial I have said or done anything which has suggested to you that I am inclined to favor the claims or positions of any party, you will not be influenced by any such suggestion. I have not expressed nor intended to express, nor have I intended to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inference should be drawn from the evidence. If any expression of mine has seemed to indicate an opinion relating to any of these matters, I instruct you to disregard it. 7. You are admonished that no juror may declare to a fellow juror any fact relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after the trial has retired that he, she, or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose such situation to me in the absence of the other jurors. This means that if you learn during the course of the trial that you were acquainted with the facts of this case, or the witnesses, and you have not previously told me of this relationship, you must then declare that fact to me. You communicate to the court through the bailiff/marshal. During the course of this trial, the attorneys for both sides and court personnel, other than the bailiff/marshal, are not permitted to converse with members of the jury. These individuals are not being antisocial. They are bound by ethics and the law not to talk to you. To do so might contaminate your verdict. You are admonished additionally that you are not to visit the scene of any of the acts or occurrences made mention of during this trial, unless specifically directed to do so by the court. Do not undertake any investigation of the case on your own or endeavor to research legal or factual issues on your own. 8. You must decide all questions of fact in this case from the evidence received in this trial and not from any other source. You must not make any independent investigation of the facts or the law or consider or discuss facts as to which there is no evidence. This means, for example, that you must not on your own visit the scene, conduct experiments, or consult reference works for additional information. 9. The credibility or believability of a witness should be determined by his or her manner upon the stand, his or her relationship to the parties, his or her fears, motives, interests, or feelings, his or her opportunity to have observed the matter to which he or she testified, the reasonableness of his or her statements, and the strength or weaknesses of his or her recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. 10. In determining whether any proposition has been proved, you should consider all evidence bearing on the question without regard to which party produced it. 11. You should decide the case for or against each plaintiff separately as if were a separate lawsuit. Each plaintiff is entitled to a separate consideration of his/her or its own claims and defenses. Unless I tell you otherwise, all instructions apply to each plaintiff. You should decide the case for or against each defendant separately as if were a separate lawsuit. Each defendant is entitled to separate consideration of his/her or its own claims and defenses. Unless I tell you otherwise, all instructions apply to each defendant. 12. When you retire to consider your verdict, you must select one of your members to act as a foreperson, who will preside over your deliberations and will be your spokesman here in court. During your deliberations, you will have all the exhibits which were admitted into evidence, these written instructions, and forms of verdict which have been prepared for your convenience. In civil actions, 3/4 of the total number of jurors may find and return a verdict. This is a civil action. As soon as 6 or more of you have agreed upon a verdict, you shall have it signed and dated by your foreperson and then return with it to this room. 13. A party may persuade you by the evidence presented in court that what he or she is required to prove is more likely to be true than not true. This is referred to as the burden of proof. After weighing all of the evidence, if you cannot decide that something is more likely to be true than not true, you must conclude that the party did not prove it. You should consider all the evidence, no matter which party produced the evidence. 14. The evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts admitted or agreed to by counsel. There are 2 types of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw or heard or did. Circumstantial evidence is the proof of one or more facts from which you could find another fact. The law makes no distinction between the weight to be given either to direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulate, meaning to agree, to the existence of a fact, you must accept the stipulation of evidence and regard that fact as proved. Questions are not evidence. Only the answer is evidence. You should consider a question only if it helps you understand the witness's answer. Do not assume that something is true just because a question suggests that it is. You must also disregard any evidence to which an objection was sustained by the court and any evidence order stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. If the court has instructed you that you must accept a fact as proven or draw a particular inference, you must do so. If the court has instructed you regarding a presumption regarding evidence, then you must consider that presumption as well. 15. Where relevant evidence which would properly be a part of this litigation is within the control of one party whose interest it would naturally be to produce it, and they fail to do so without satisfactory explanation, the jury may draw an inference that such evidence would have been unfavorable to that party. The same can be inferred from improperly altered evidence. Any evidence means a logical and reasonable conclusion of a fact not presented by direct evidence, but which, by process of logic and reason, the jury may conclude exists in the established facts. 16. When evidence is willfully suppressed, the law creates a rebuttable presumption that the evidence would be adverse to the party suppressing it. Willful suppression means the willful or intentional spoliation of evidence and requires the intent to harm another party or their case through its destruction and not simply the intent to destroy evidence. When a party seeking the presumption's benefit has demonstrated that the evidence was destroyed with intent to harm another party or their case, the presumption that the evidence was adverse applies, and the burden of proof shifts to the party who destroyed the evidence. To rebut the presumption, the destroying party must then prove by a preponderance of the evidence that the destroyed evidence was not favorable. If not rebutted, the jury is required to presume that the evidence was adverse to the destroying party. 17. Before trial, each party has the right to ask the other parties to answer written questions. These questions are called interrogatories. The answers to the interrogatories are also in writing and are sworn to under oath. You must consider the questions and answers that were read to you the same as if the questions and answers had been given in court. 18. Before trial, each party has the right to ask another party to admit in writing that certain matters are true. If the other party admits those matters, you must accept them as true. No further evidence is required to prove them. You will regard those matters as being conclusively proved as all such matters of fact which were expressly admitted by the parties or which the parties failed to deny. If there are multiple parties to the litigation, these matters must be considered true only as they apply to the party who admitted they were true. 19. The credibility or believability of a witness should be determined by their manner upon the stand, their relationship to the parties, their fears, motive, interest, or feelings, their opportunity to have observed the matter to which they testified, the reasonableness of their statements, and the strength or weaknesses of their recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of that testimony which is not proved by other evidence. Whenever in these instructions I state the burden or the burden of proof rests upon a certain party to prove a certain allegation made by him, the meaning of such an instruction is this: that unless the truth of the allegation is proved by a preponderance of the evidence, you shall find the same not to be true. The preponderance of the evidence means such evidence as when weighed with that opposed to it, has more convincing force and from which it appears that the greater probability of truth lies therein. 21. The preponderance or weight of evidence is not necessarily with the greater number of witnesses. The testimony of one witness worthy of belief is sufficient for the proof of any fact and would justify a verdict in accordance with such testimony, even if a number of witnesses have testified to the contrary. If, from the whole case, considering the credibility of witnesses and after weighing the various factors of evidence, you believe that there is a balance of probability pointing to the accuracy and honesty of one witness, you should accept his testimony. 22. To prove a claim of civil conspiracy, plaintiff has the burden of proving each of the following: two or more persons or entities who, by some concerted action, intended to accomplish an unlawful objective for the purpose of harming plaintiff, and two, plaintiff suffered damages as a result of this act or acts. 23. A communication is defamatory if it tends to harm the reputation of the plaintiff as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. Words or conducts or the combination of words and conducts can communicate defamation. Defamation occurs when the defendant made a false or defamatory statement concerning plaintiff. An unprivileged publication of the statement was made to a third person. Defendant was at least negligent in making the statement, and plaintiff sustained actual damage as a result of the statement. 24. In order to establish a claim of defamation per se, the plaintiff must prove the following elements by a preponderance of the evidence: false or defamatory statement by defense concerning the individual plaintiff, unprivileged publication of the statement to a third party, some level of fault amounting at least to negligence, and actual or presumed damages. Damages will be presumed if the defamation tends to injure plaintiff in his business or business reputation. Defamation per se. 25. To constitute defamation per se, the statement must be one which would tend to injure the individual plaintiff, Kurt Harris, in his trade, business, profession, or office. 26. Libel per se refers to certain libelous, written, and defamatory communications which subject a defendant to liability without any showing that the publication of the communication was a legal cause of special damages to the plaintiff. A libelous communication constitutes libel per se if its defamatory meaning is apparent from the communication itself and without reference to extrinsic facts. In determining whether a communication constitutes libel per se, the words used are to be given the plain and natural meaning that they would normally convey to those to whom they were directed, in light of the circumstances under which the words were used. 27. Publication of a defamatory matter is its communication intentionally or by a negligent act to one other than the person defamed. One who intentionally and unreasonably fails to remove defamatory matter that one knows to be exhibited on property in their possession or under their control is subject to liability for its continued publication. 28. For Mr. Harris to recover as to the defamation claims, Mr. Del Casal's or Mr. Franklin's statements must have been statements of fact, not opinion. A statement of fact is one that can be proved to be true or false. In some circumstance, Mr. Harris may recover if a statement phrased as an opinion implies that a false statement of fact is true. In deciding this issue, you should consider where the average reader or listener would conclude from the language of the statement and its context that Mr. Del Casal or Mr. Franklin was implying that a false statement of fact is true. 29. In order to establish a claim of theft/conversion or corporate theft/conversion, the plaintiff must prove the following elements by a preponderance of the evidence. A distinct and intentional act of dominion by one which is wrongfully exerted over the property of another. An act committed in denial of or inconsistent with the rightful owner's use and enjoyment of the property. Act committed in derogation, exclusion, or defiance of the owner's rights or title in the property, and causation and damages. 30. In order to establish a claim for breach of contract, the plaintiff must prove the following elements by preponderance of the evidence. Valid contract, offer, acceptance, and consideration exists between plaintiff Kurt Harris and defendant Ernest Del Casal. Defendant Ernest Del Casal breached the contract or failed to render performance when it became due. Defendant Ernest Del Casal's breach or failure of performance was unexcused. All conditions precedent to defendant Ernest Del Casal's duty to perform were fulfilled by plaintiff or were excused. Plaintiff Kurt Harris was damaged by the breach. Causation and damages were a foreseeable consequence of a particular breach. Causation is an essential element of liability. In order to establish a claim of business disparagement, the plaintiff Kurt Harris Esquire PC must prove the following elements by clear and convincing proof. A false and disparaging statement that interferes with the plaintiff's trade or business or are aimed at the business's goods or services. The statement is not privileged. The statement is made with malice and proof of special damages. 32. As an element of damages, the plaintiff must present evidence of a general decline of business, but the plaintiff must also have to eliminate other potential causes of lost business in order to demonstrate that the general decline of business is attributable to the offending statement. 33. A proximate cause of injury, damage, loss, or harm is a cause which in natural and continuous sequence produces the injury, damage, loss, or harm, and without which the injury, damage, loss, or harm would not have occurred. 34. A proximate cause of injury, damage, loss, or harm is a cause which is a substantial factor in bringing about the injury, damage, loss, or harm. 35. A plaintiff may be able to recover compensatory damages for such losses as lost earnings and profits, decreased business traffic, and or adverse employment consequences. 36. No definite standard or method of calculation is prescribed by law by which to fix reasonable compensation for damages, nor is the opinion of any witness required as to the amount of such reasonable compensation. Furthermore, the argument of counsel as to the amount of damages is not evidence of reasonable compensation. In making an award for compensation, you shall exercise your authority with calm and reasonable judgment, and the damages you fix shall be just and reasonable in light of the evidence. 37. Whether any of the elements of damages have been proven by the evidence is for you to determine. Neither sympathy nor speculation is a proper basis for determining damages. However, absolute certainty as to the damages is not required. It is only required that each of the plaintiffs prove each item of damage by a preponderance of the evidence. 38. If you find that plaintiffs suffered damages as a proximate result of the conduct of the defendants, or each of them, and upon which conduct you base a finding of liability, you may then consider whether you should award punitive or exemplary damages against defendant Ernest Del Casal only, and or Michael Franklin Jr. only, for the sake of example by way of punishment. You may, in your discretion, award such damages if, but only if, you find, by a preponderance of the evidence, that said defendant was guilty of oppression or malice in the conduct upon which you base your finding of liability. 39. If you find that plaintiffs suffered damage as a proximate result of the defendant's conduct, and that defendants are liable based on that conduct, you may then consider whether you should award punitive or exemplary damages against Ernest Del Casal only, or Michael Franklin Jr. only. Punitive or exemplary damages are to make an example of or punish wrongful conduct. You have discretion to award such damages only if you find by clear and convincing evidence that the defendant was guilty of malice in the conduct providing your basis for liability. Malice means conduct which is intended to injure a person, or despicable conduct which is engaged in with a conscious disregard of the rights or safeties of others. Oppression means despicable conduct that subjects a person to cruel and unjust hardship with conscious disregard of the rights of that person. Fraud means an intentional misrepresentation, deception, or concealment of a material fact known to a defendant with the intent to injure or deprive a person of rights or property. Conscious disregard means knowledge of the probable harmful consequence of a wrongful act and a willful and deliberate failure to avoid these consequences. The law provides no fixed standard as to the amount of such punitive damages, but leaves the amount to the jury's sound discretion, exercised without passion or prejudice. In arriving at any award of punitive damages, you are to consider the following: the reprehensibility of the conduct of the defendants, the amount of punitive damages which will serve the purposes of punishment and deterrence, taking into account the defendant's financial conditions. 40. The defendants acted with malice when they either 1. Published the offending statement with the intent to cause monetary harm to the business, or 2. The defendants knew the statement was untrue, or the defendant had a high disregard for the statement's truth. 41. The court has given you instructions embodying various rules of law to help guide you to a just and lawful verdict. Whether some of these instructions will apply will depend upon what you find to be the facts. The fact that I have instructed you on the various subjects in this case must not be taken as indicating an opinion of the court as to what you should find to be the facts, or as to which party is entitled to your verdict. 42. It is your duty as jurors to consult with one another and to deliberate with a view toward reaching an agreement, if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but should do so only after a consideration of the case with your fellow jurors. And you should not hesitate to change your opinion when convinced that it is erroneous. However, you should not be influenced to vote in any way on any question submitted to you by the single fact that a majority of the jurors, or any of them, favor such a decision. In other words, you should not surrender your honest convictions concerning the effect or weight of evidence for the mere purpose of returning a verdict, or solely because of the opinion of other jurors. Whatever your verdict is, it must be the product of a careful and impartial consideration of all the evidence in the case under the rules of law as given you by the court. 43. If, during your deliberations, you should desire to be further informed on any point of law or hear again portions of the testimony, you must reduce your request in writing, signed by the foreman. The officer will then return you to court, where the information sought will be given you in the presence of the parties or their attorneys. Readbacks of testimony are time-consuming and are not encouraged unless you deem it a necessity. Should you require a readback, you must carefully describe the testimony to be read back so the court reporter can arrange his notes. Remember, the court is not at liberty to supplement the evidence. 44. Now you will listen to the arguments of counsel, who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing you the application thereof to the law. Whatever counsel may say, you will bear in mind that it is your duty to be governed in your deliberations by the evidence as you understand it and remember it to be, and by the law as given you in these instructions, and return a verdict which, according to your reason, candid judgment, is just and proper. Counsel, the plaintiff be prepared to close.
Yes, Your Honor.